the presentation over to John and Frank. You may begin.
Good morning, everyone. Hi, my name is John Porta. I'm an attorney at Jackson Lewis, and I'm also the Government Affairs Director for the State Council. I want to welcome everyone to this webinar, and I'm joined by my colleague, Frank Kania. Frank, if you just want to introduce yourself and explain your role on the State Council as well.
Sure. Good afternoon, everyone. My name is Frank Kania, and I'm President and Managing Partner of Driven HR, HR consulting firm in Rochester, New York. And I'm also the Federal Advocacy Director for the New York State SHRM Council.
Thanks, Frank. So today what we wanted to do was, in our roles with the State Council, we wanted to provide individual chapter legislative chairs and anyone that's a member of a local or the state SHRM with legal updates on pending legislation that's passed, and legislation that is on the horizon. So, and in New York, I think it's particularly important. A lot has happened and a lot will be happening on the legislative front. I like to say it's the Californization of New York. We're basically seeing a lot of employee-friendly legislation. We're also seeing President Cuomo signing orders. We also are seeing legislative or agency action. So today is just sort of a wrap-up. I'm going to speak about the New York State specific things, and then Frank's going to join in towards the middle of the presentation to talk about one of the most significant things going on with respect to the federal law, in particular, the changes to the white-collar exemptions under the Fair Labor Standards Act. So I'm going to get started on let's talk about what's passed. So I'm going to start off with what was passed in the New York State Legislature, and then I'm going to talk about what failed, because I think what failed shows what we likely will see in the beginning of next year's legislative session. So the first thing that we see here is this is all part of we're going to see a lot dealing with gender discrimination. And for those of you who are familiar with it, there's something called the New York Women's Agenda. And Governor Cuomo is a staunch advocate and strong supporter for this agenda, which basically, in a nutshell, is leveling the playing fields for females in the state of New York. If you look at the background on this agenda, it really talks about New York used to be one of the most progressive states on women's rights. I mean, it's where suffrage began in the 1800s. So New York used to be a pioneer, and the opinion of those backing this bill seem to think that New York is falling behind other states, and New York should really be a trailblazer and a leader on women's rights as it was in the past. So a lot of what we've seen come up this legislative session really deals with gender equality in the workplace. The first one is prohibits differential in pay based on sex. So this is a law signed by Governor Cuomo, passed by both houses, and basically it deals with pay disparity. So under existing law, an employer can defend a pay discrimination claim by showing that the difference in pay is justified by a seniority system, a merit system measuring earnings based on quantity or quality of work, or any other factor other than sex. This last piece that I just mentioned, any other factor other than sex, that's like a catch-all. And the reason why most female employees do not prevail on gender pay equity cases is because this catch-all. This catch-all basically makes it very easy to defend against an equal pay claim. So now the law is being changed, and the law basically is changing that last portion on any other factor other than sex, and the law now provides that a bona fide factor other than sex, such as education, training, or experience. So I believe that this is going to increase the number of pay disparity claims brought in New York, because most plaintiffs' attorneys in the past have stepped away from bringing gender pay equality cases because there's an understanding that it's very difficult to prove. This is now taking that sort of catch-all, which was what everyone really used in order to prove their cases from the, an employer's perspective. It's now saying it basically, in order to pay someone less, it really needs to be related to education, training, or experience. So absent and employers' ability to demonstrate and highlight that that's why a woman is being paid less than a man, it's going to be more difficult for an employer to prove their case. A little takeaway from this is we should be looking at our job descriptions and looking at our job categories and just doing a little test as to whether or not we believe that there are pay inequities between male and female employees. And basically the sort of the mantra and the mission and the spirit of the statute is equal pay for equal work. If two people are doing the same job, contributing the same to the business, we need to be able to justify why one is making more than the other. The second piece of what's passed as part of this is, this is a big one, I think, extends existing sexual harassment protections to employees of small employers. So statistics show that 60% of the employers in the state of New York have less than 4 employees. And until now, employers that had less than 4 employees were not covered by the New York State human rights law. Now the human rights law is amended to include only with respect to sexual harassment. So age discrimination, race discrimination, those claims against employers, that still does not apply to employers of less than 4 employees. But if it's a sexual harassment claim, that now includes all employers in the state of New York. So we're going to see a lot of employers who typically weren't covered in the past will likely be covered moving forward in the future. So we're going to see an increase in the number of sexual harassment discrimination claims. So if you're an employer that has less than 4 employees, you're going to be on the radar of the State Division of Human Rights. Another piece of the women's agenda that was passed is everyone should be amending their handbooks. Take a look at your list of protected categories. We now have to add familial status into that list of protected categories. This really, I don't know if anyone remembers in 2007, the EEOC issued guidelines on caregiver status and basically suggested that if you are making employment-related decisions based upon somebody's role as a caregiver for young children or older individuals, you most likely are making decisions based upon, and you likely will be disproportionately screening out women, because typically women tend to be the primary caregiver of their children, more so than their male counterparts. So this familial status piece really is just reinforcing what the EEOC's guidelines were in 2007. In short, employers cannot make employment-related decisions based upon somebody's caregiver status. Right? We can't ask whether or not somebody has children if they're interviewing for a job. This is sort of HR 101, but again, it's now being codified in the law, and all employment handbooks or any policies against any policies regarding equal employment opportunities should include a provision of familial status as a protected category. Some additional measures that passed in the legislature, the workplace accommodations regarding medical conditions resulting from pregnancy. This is really just codifying into law what most employers in New York were doing. We've always suggested that pregnancy is a disability and it should be treated as a disability regardless of the fact that it's temporary, and that all employers should make any reasonable accommodations to a pregnant employee just as if they would make those accommodations for any other disabled employee. This is basically just memorializing what most employers in the state of New York were doing. Specifically, if you look at the definition of disability under New York State human rights law, that definition is really broad, so it was always our belief that pregnancy would have been covered. So this really probably doesn't change much from what employers are doing. The one thing, though, that I do suggest that most employers take a look at is we are actually suggesting that employer handbooks, that you actually have a separate disability accommodation policy, since there's such a drive to have employers really notify employees about accommodation requests, where to go for accommodation requests. So, I typically now am carving out separate accommodation policies, and in that accommodation policy, I include pregnancy-related impairments as part of the list of disabilities and advise employees where they should go right in that handbook to discuss possible accommodations. Remember, this doesn't mean that every request for an accommodation needs to be granted. We're still looking in the parameters of the law, which basically says that employees should be provided an accommodation so long as it's not an undue hardship on an employer's obligation. So that's sort of a summary of what the law is. And of course, our favorite, which is old news to everyone. This was the first thing passed in the 2015 legislative session, repeal of the annual wage notice provisions of the Wage Theft Prevention Act. So in January, we all don't have to hand out those annual notices. We still have to hand out those notices at the time of hire. And we still have to hand out those notices if somebody's pay is changing. If somebody's pay is increasing, we do not have to give out the notice if your wage statements are correct. But if you are decreasing somebody's pay or salary, they need to be provided a notice under their circumstances. But we don't have the annual wage notice requirements any longer. It was a compromise, though, because with this piece of legislation, the compromise was, okay, we'll repeal the annual wage notice, but the penalties associated with failing to provide the notice have doubled. So give and take. Here's just a brief summary of what was not approved and what failed this session. The Credit Privacy and Employment Act, which would prohibit the use of consumer credit reports in hiring and employment determinations. Anyone who's downstate in New York City is sort of the trailblazer in passing all of this legislation, really with respect to pre-employment background checks. This did not pass. I could see this coming up. Basically, it's a prohibition on conducting any credit checks on any employees. According to the justification of the law, somebody's credit really has no bearing on whether or not they can perform the job or whether or not they'll be a good performer in their job. Quick contrast to the New York City. If anyone is in New York City now prohibits the use of credit checks, pre-employment credit checks, or even for current employees, except New York City has a couple of exceptions. So if it's a high-level executive in an organization that will have signatory authority for $10,000 or more, that individual is exempt. That individual, a background check can be run on them. There are certain loan originators and loan mortgage officers that you could run background checks on in New York City, credit background checks. So there are some exceptions. Interestingly, there are exceptions under the New York City law. However, under the proposed legislation on the state level, there were no exceptions and no credit reports could be run on anyone. The other thing that failed in the legislature this year is ban the box. This is a lot of ways to say ban the box. For those of you not familiar with the trend throughout the United States, ban the box basically is a law that prohibits any employer from asking criminal conviction inquiry questions on the employment application. The rationale in the background for that is criminal conviction inquiries. If employers are making decisions strictly based upon criminal conviction inquiries, you're going to be disproportionately screening out certain minorities. So that's on the one hand. And then on the other hand, the goals of reformation, somebody coming out of prison, in order for those individuals to really assimilate back into society, they need to be provided with gainful employment. And if you have employers not hiring people just because they have a criminal background, you're going to be defeating that purpose of trying to assimilate and reform these former criminal convicts. So this pending legislation basically would require an employer to first make a conditional offer of employment, which is basically you have the job pending the background check. And that's the first time that you could ask the background check question. And then once you ask the background check question and run the criminal background check, if something comes back on the conviction report, we have to go through everyone should be familiar with the New York State Article 23A factors. Basically, it's factors about whether or not you have to go through that analysis to determine whether or not the employee is a candidate for that job. So basically just summarizing the Article 23A factors, it's how long ago did the person was the person convicted of a crime? What have they done since they've been convicted? How old was the individual when the crime was committed? related to the job is the actual conviction. So for example, if somebody was convicted of driving while intoxicated and the position that you're hiring them for is an office position that doesn't require any driving on behalf of the company, it's unlikely that conviction would have any bearing on the employee's ability to perform the job. And of course the backdrop is New York's public policy is to hire individuals who have a criminal conviction background. So that analysis still stays in place. It just comes along later on in the process. I could see this being passed next year. I think this is a hot ticket item. We've already seen it passed in New York City. The New York City law is very, very strict and very employee friendly. The New York City law actually requires that if you're going to reject somebody based upon their criminal conviction, that you have to actually provide them a summary in writing of your Article 23A analysis. So fortunately, the drafted legislation for New York that didn't pass this year wasn't as strict and didn't require written notification to the employee about the Article 23A factors. But again, I could see this as something being pushed through next year. Of course, next year, the big topic that's going to be in the legislature with respect to labor and employment matters is going to be increasing the minimum wage. Governor Cuomo, this is going to be sort of the driving force of the next session. Governor Cuomo strongly supports increasing the minimum wage in the state of New York to $15 an hour, which is high above the I don't know if it's $8.60 or whatever of the $8 that currently is the minimum wage in New York. So I see that as being I see that being, the minimum wage piece being the big debate in the legislature for the next session. Couple of other things that were not approved in New York. The first one we're talking about here in New York, the right to review personnel files. Employees in New York typically do not have a right to review their personnel files, current employees and former employees. This legislation that was not passed, it's a little goofy, and I see why it wasn't passed. Basically would permit employees to review their personnel files at least yearly and to make copies of it. That included not only current employees but former employees. The justification behind it was transparency, and that employees should be provided with access to information and should be able to see whether or not supervisors are putting secret documents in the personnel file. It's a silly statute, right? I don't think that this is something that's going to get a lot of traction, but again, most employers should be transparent in terms of performance reviews. If an employee is being disciplined or there's any documentation about the employee's performance, that documentation should be provided to the employee. Again, so not even a need for this statute, but if most employers are advising their employees and putting it in writing and letting them know when there's issues with their performance, there wouldn't even be a need for this statute. Again, we should always make sure that there's no super secret personnel files and people not secretly putting things into employees' personnel files. That just turns out to be a problem if there's ever litigation. The next piece that failed, and I don't think will ever pass, according to Governor Cuomo, is provides workers' compensation benefits for injury or sickness, pregnancy or family leave, applies to an employee and to family members taking family leave to care for an employee. So this piece is paid family leave. It's basically what this failed piece of legislation deals with. And the way that it would pay for that paid leave is that it would come through the New York State Workers' Compensation Fund. Cuomo has gone on record to state that he really doesn't believe that there's a desire in New York to fund this, and that the only way that he would consider signing off on this legislation is if it was funded primarily by the employee through payroll deductions. So I don't see this, those who were in support of the women's agenda, a number of advocates, female advocates in New York State were really upset with his comments on this. But again, I think that, this would increase the costs for New York State employers. It would also, so that's sort of the impetus by why I believe that we're not going to have Cuomo supporting this legislation. It may be brought up to the legislature next year, but I certainly do not believe that it will be passed. A couple of others that were not approved, requires prior written notice upon hiring. the types of electronic monitoring which may occur. So this would be a requirement for all employers in New York that if they were going to review employees' emails or their telephone calls or anything like that, that employers would have to provide advance notification of that. Again, most handbook policies should deal with monitoring. Employees should, I always like to have a policy in a handbook that advises employees that we have the right to monitor the emails or the electronic communication systems that they use. Let them know that there's no expectation of privacy in their emails and in the websites that they search. Although it's not required by law, I strongly suggest that most employers do have this as part of their handbook. I always like to decrease an employee's expectation of privacy. This way, you know, if they're sending emails that are inappropriate, they don't come back to you and say, well, I didn't know you were monitoring that. I think it's important that everyone have that in their handbook anyway. This other legislation that did not pass would impose significant paperwork and record retention requirements on employment agencies. This really deals with, there's a number of employment agencies in New York that in order to assist you in getting a job, you have to pay a fee. So on average, I think the statistics show that on average, and this is really for lower wage employers, you know, sort of employees at the minimum wage threshold. And a lot of employment agencies were charging just to get in the door and to get on the list like a $122 fee. And more often than not, all those individuals that paid the fee were not guaranteed employment and actually did not receive employment. So this legislation was proposed, and the justification was that, you know, you cannot charge a fee as an employment agency unless the person actually gets a position. That's sort of a quick way of summarizing that legislation. This is just a summary slide of all the things that we just talked about with respect to the New York Women's Agenda. The one thing that I didn't touch upon that I think is very significant is the third bullet underneath the main bullet, and it's collection of attorney's fees by successful plaintiffs. One thing that we as defense attorneys love, what makes the New York State human rights law less desirable to plaintiffs, is the fact that attorney's fees are not available under the New York State human rights law. What does that mean? That means that because attorney's fees aren't available, there are less attorneys that are interested in taking that person's case, and the value of the case is significantly less. This is why people don't like attorneys. The value of a case goes up significantly when attorney's fees are part of the equation. So what this change basically says is if you have a case based upon gender discrimination, remember gender discrimination also includes sexual harassment, and there's two types of sexual harassment, right? There's the hostile work environment sexual harassment, and then there's the quid pro quo sexual harassment. We can go on and on about those, but all of those claims, if somebody is bringing one of those claims, they are now eligible to receive attorney's fees. I see this as having a significant impact in this state, and everyone should be on the watch out for this, because what it will do is more people are going to file New York State law case. They're going to file claims in New York State law as opposed to under federal law. New York State law is a little bit slower than federal law. You know, the New York State courts are a little bit slower than federal law. Plaintiffs' attorneys know that it's less likely that a case will be dismissed in the state courts than in federal courts. So again, I think we're going to see an increase in activity in our state courts. More people will be more likely to bring gender and sexual harassment claims. So I think this just is an invitation to increase litigation with respect to gender discrimination. So again, everyone should just be looking at, you know, their policies, maybe consider, given the heightened, you know, given how these cases can be more expensive, maybe management training on sexual harassment. I always think that's important for every employer. You know, California has a mandatory requirement that every 2 years all supervisory employees receive training. I recommend it in New York, whether it be an hour, half hour, or if it's just once a year, you're reminding your employees about the sexual harassment policy and just rolling it out to them. I think it's really important for all New York employers to take a look at their anti-harassment policies and make sure that employees and specifically managers are trained on the policy. One other thing, another piece of legislation that Cuomo signed, remember a couple of years ago, The New York labor law was so strict, and you couldn't make any deductions for an employee, any deductions from an employee's paycheck. Then the labor law was amended in 2012 and basically says that, well, you can make deductions for loans to employees and to overpayments. And there was a specific formula and specific notice requirements, but you could do it. In 2012, the law permitted employers to take back what was lawfully theirs. That provision was set to expire on November 6th, 2015. We were all a little bit nervous because we thought, we'd revert back to the old way of New York law where you couldn't deduct for anything and you basically had to get on your hands and knees and beg the employee to pay you back. And they could say, they could laugh at you and say, I don't have to pay you back. And then you could take them to small claims court. But the governor has extended that, so now the ability to make deductions under certain limited circumstances has been extended to November 6th of 2018. If anyone has any questions about sort of what needs to be included in that authorization from the employee to make those deductions, I could talk about that offline. But again, it's pretty strict on what needs to be included in the authorization from the employee. So although the law permits you to make those deductions, there are some somewhat rigorous requirements in order to make those deductions from the employee's paycheck. It's important, Governor Cuomo also has, now we're talking about non-legislative stuff, things that, not laws that have been passed, but just initiatives, specifically Governor Cuomo's initiatives. He is creating an anti-retaliation and mediation unit in support of recently established task force charged with investigating wage theft, child labor, and other practices. Governor Cuomo has infused $700,000 into the Department of Labor to assist them in their investigation efforts into employers who violate the wage laws. We are going to see an increase in the number of investigations conducted by the New York State Department of Labor. And with that increase, we're going to see he's created a mediation unit. So the way that anyone who had the unfortunate experience of being audited by the DOL, it really is a DOL investigation. But now what what Governor Cuomo has created is a mediation unit. So it's going to be similar to what we see at the EEOC, which is, complaint comes in, there's going to be a desire to try and mediate these things early on. The goal is to process more complaints, resolve more complaints, and get money in the pockets of more employees. So we are going to see heightened activity at the New York State Department of Labor with any type of, non-payment of wages for employees. This is just what the governor said, pay cards and paychecks, additional non-legislative action by the Attorney General's office. Any employer who's going to be using pay cards, there's some restrictions that are being imposed on that, and the restrictions are here. I want to get to Frank. So a lot of New York State employers do not use pay cards, but in the event that you choose to use pay cards as a form of compensating your employees, there has to be written consent by the employees. You can't force the employee to use direct deposit. Can't force the employee to use pay cards. The employee has to consent to it. They have to have, that consent needs to be in writing. The employee also has to have access to the money at any time, and there has to be, if you're using a pay card, you have to have access. There needs to be an ATM or a machine that they could get the money out of that's within a reasonable commuting distance from their place of work or from their home. So these proposed rulemakings make it virtually impossible, in my opinion, to use payroll cards as a form of payment for your employees. On-call schedule, and this is another thing, all employers should be looking at whether or not they have a practice of on-call. On-call, really in the retail industry is where we see this quite frequently, but on-call scheduling is where employers are told, listen, call in shortly before your shift to see if we need you. Basically the justification and why the Attorney General and Governor Cuomo are interested in eliminating the on-call practice is because they believe that and other, family rights activists believe, one, it makes individuals' lives in terms of payment and how much they're going to be making, it makes it uncertain, right? They don't know whether they're going to be making money this week or not, so it makes it difficult to plan and budget accordingly. Another issue that this affects on-call scheduling is family care. If somebody has young children or an elderly person that they take care of and they are called into work, they have to, hire childcare and get somebody to assist with babysitting for the children. If somebody is told not to come into work and they've already hired a babysitter to come in, that creates a lot of familial problems in terms of, supporting a family. So the Attorney General's office actually issued subpoenas requesting information from some rather large New York State employers, asking about their practices. So again, for the most part, we strongly suggest that everyone take a look at whether or not they use on-call. And if you're sending employees home or telling them not to come in, everyone should be reminded of the show-up pay in New York. So if an employee is ready, willing, and able to work, and they come to work and they report to work and they're told to leave, they need to be paid 4 hours at the minimum wage. So it's just something to remember if you do have on-call procedures. And when they say report in doesn't strictly mean actually physically showing up to the work. If you look to the workplace, if you look at A.G. Schneiderman's request, he talks about if somebody's required to text or call in, that's the same thing as reporting. So again, everyone should be aware of the New York reporting pay requirements. And I think given the trend in New York, I could see pending legislation next year prohibiting on-call scheduling in its entirety. And with that, I'm going to turn it over to Frank. Frank's going to talk about, I sort of gave you an overview of the state law changes, and Frank is going to touch upon and discuss with you guys federal law.
All right, thanks, John. And John, when I need you to move the slide forward, I'll just say next.
Sure.
Okay, so next. So on July 15th, the administrator of the Wage and Hour Division of the Department of Labor issued a 15-page document that talks about independent contractor status. And basically that 15 pages really provides some guidance on how to determine whether or not someone is an independent contractor or an employee under the Fair Labor Standards Act. If you take the time to read it like John and I have, because I can't speak for him, but I know I have no life, so I read all of these things, you can see that really the Department of Labor does not want anyone to have independent contractors working with them. As part of that, the administrator's interpretation embraces the economic realities test, which we'll go through in a couple minutes, but it's a really strict test that many employers will find very difficult to pass with any independent contractors they may have working with them. Okay, next. Next. Okay. So stepping back for a second, the Fair Labor Standards Act defines to employ as to suffer or permit to work. Now, fortunately, a lot of our employees haven't read the FLSA, so they don't see that, the definition says that they're suffering and being permitted to work every day. But if they did, I think a lot of them would probably call in sick more often. Next. So the suffer or permit concept has a very broad applicability to the employment relationship. And according to the administrator, the standard was specifically designed to ensure as broad a scope of statutory coverage as possible to as many workers as possible. So again, the idea is if someone is working with an employer, that they be an employee, not an independent contractor. Next. So clearly, the Department of Labor's stated priority is to correct what they believe has been a history of serious and widespread worker misclassification. And two areas that they're really focusing on, the first being independent contractor misclassification. This makes it very easy for collective actions to be certified. And a lot of businesses, unfortunately, still have that false assumption that providing the title of independent contractor or some other freelancer or contractor, something like that, makes it okay. Paying someone and providing a 1099 at the end of the year or even having an independent contractor agreement in place is not determinative. Unfortunately, having even the best agreement written by some of the best attorneys you can would not necessarily mean that that individual is an independent contractor. So we have to be careful with that assumption as well. Next. Some key elements that you should generally think of when looking at independent contractor status. Is there a lack of direction and control? So is the individual, the worker, able to direct and control their own work? Do they regularly work as a contractor? So do they have their own business? Do they have other clients? Do they have things like signage or a website, any type of t-shirts, hats, anything like that that indicates that they're in business for themselves? Do they cover their own expenses, or are those expenses that they incur reimbursed by the employer? Does it require independent skill and knowledge to do what they do? And is there an opportunity for gain or risk of loss if they don't run their business correctly? And if for some reason they're not able to attend to the work on a particular day or during a particular period of time, can they send someone else from their company as a substitute? So those are things to keep in mind. Next. Okay, so the economic realities test that the Department of Labor will now use going forward. The first step is the extent of the work performed is an integral part of the employer's business. So one of the best examples that I can think of is a company, say a law firm or an HR consulting firm or someone who hires an individual to clean their office at night. We're not in the business of cleaning offices. The person that we hire is not doing anything that is integral to our business. Second, the degree of the worker's opportunity for profit and loss, whether or not that's controlled by the employer. So do I set the rates for the cleaning crew, or do I put it out to bid and accept or reject specific bids? The next, C, is the extent of the relative investments of the employer and the worker. This one's kind of scary. What they're going to look at there is the investment that that independent contractor, quote unquote, has in their business versus what the employer has in their business. So a good example is a welder. If you have a welder who has a truck and welding equipment, but then they subcontract work through a welding company that has millions of dollars invested in the business, the independent contractor's relative investment is going to be minuscule compared to that employer's investment in the business. So that's one that may, in many cases, be very difficult to overcome. Next. Whether the work performed requires special skills and initiative. So historically, we've thought, well, if someone is a skilled tradesperson or they have a special skill that's required for the work, that's enough. But the example that the Wage and Hour Administrator provides is one of a carpenter who has, great skills, but they're not making decisions on the work site. They're just simply going in and doing what they're told. And regardless of how complicated or how much skill is necessary in doing the work that they're doing, if they're not making important decisions, then the skill and initiative isn't really special. The permanency of the relationship. So is it a relationship that goes on for a few weeks or a few months, or is it a situation where the worker comes back time after time after time for different projects, or the same project going on and on and on for a long time? And then the degree of control exercised or retained by the employer. So here, I had an experience with the New York State Unemployment Division recently with this type of situation where the employer doesn't have to exercise control. They just have to retain the right to control that worker. And if they're retaining the right to control the worker, then that may be enough to fail this part of the test as well. Next. So as I mentioned, there's a 15-page document that was put out, and some of the quotes that come directly from that document. Applying the economic realities test in view of the expansive definition of the Act, most workers are employees under the FLSA. That puts it right out there. That is the opinion of the Federal Department of Labor, that most workers are employees under the Fair Labor Standards Act. Also, the analysis should be applied in determining whether a worker is an employee or independent contractor where the FMLA is concerned. So again, it may not just be wages that we need to be concerned about, but also FMLA. Next. The scope of employment under the FLSA is the broadest definition that has ever been included in any one act. Again, everybody's an employee unless they can be proven otherwise, and it's very difficult to prove otherwise. An employee is not permitted to waive employee status despite having signed an independent contractor agreement. So again, just because you have a great independent contractor agreement in place does not mean that that independent contractor status would hold up. And finally, a true independent contractor's work is unlikely to be integral to the employer's business. If that independent contractor is doing something, that worker is doing something that is an important part of your business, then it's likely that that relationship would be seen as an employee, not an independent contractor relationship. And now I'm going to turn it over to John for a few slides, and then I'll be back.
Okay, so we're turning to the white-collar, proposed changes to the white-collar exemptions. And just a little history on the Fair Labor Standards Act. Fair Labor Standards Act, that's the law that sort of governs how we pay employees on the federal level. Passed into law into 1938. And it's been amended over the years, and we're going to see really the issue and the most highly litigated issue under the Fair Labor Standards Act really is those employees who employers consider to be exempt from overtime. Just as a background, these new pending changes that are looming out there, which will likely go into effect sometime in 2016, basically deals with changing and making it more unlikely that many employees in the United States are exempt from overtime. The goal of these, basically the goal of the recent legislative action with respect to the exemptions is to have less and less people considered exempt. Exempt employees are not entitled to overtime. Employees are presumed to be non-exempt. It's the employer's burden to prove an exemption. And several exemptions focus on white-collar exemptions. When we talk about the white-collar exemptions, this is where the changes are coming about. These are your executive, your administrative, your professional, your computer professional, your highly compensated exemptions. We're going to go through each of these briefly, but somebody's job title means nothing. Really what you have to look at is when you're determining whether or not somebody is exempt or non-exempt, you have to look at two things. You have to look at, one, are they paid a salary? A regular salary, that's the salary basis test, and that salary is going to go up basically double starting sometime. We're thinking that the law will go into effect in January, maybe February, but we don't have a final date on that yet. So the salary basis, that they're paid a minimum salary, which will likely be going up to $50,000 a year starting in 2016. And then also there's the salary test, and then there's the duties test. Here's just a listing of the white-collar exemptions. Highly compensated individuals making over $100,000 a year. These individuals typically are exempt from overtime. Here's some other exemptions that are less often utilized by employers. The motor carrier exemption, seasonal amusement or recreational exemption, agricultural exemption. I love this one, a wreath maker exemption. So these are less used exemptions. Two that I want to focus on are the computer professional exemption. A lot of people think that they're help desk person because they're working with computers, they're exempt. That is unlikely. Most of your computer professional exemption really deals with those employees who are coding, who are in charge of your systems, developing software. It's not your help desk people. So this is sort of a risk area for a lot of employers that I see a lot of employers often abusing the computer professional exemption. Primary duty of the computer professional exemption is sort of your computer programmers, your software engineers. And then we have this must be paid at least $4.55 per week or $27.63 an hour. Again, this is going to go up. The highly compensated test. A lot of people think that if you have somebody who's making over $100,000, the proposed regulations that Frank will get into might likely are going to increase this number. But if an employee is earning $100,000 a year and they perform one or more exempt duties, then they fall under the exemption. And there's a bunch to that, more to that, but I just want to go back a little bit to two of the exceptions that most people use, most employers use, the executive and the administrative exemption. The executive exemption, just as a refresher for everyone, and then this will segue nice into what Frank's going to talk about, is the executive exemption applies to those who are paid a salary, and we're going to talk about what that number is going to be. And then the employee's primary duty must be managing the enterprise or managing a customarily recognized department. So they really have to be management level. Additionally, in order to fall under the exemption, this executive must direct the work of at least 2 or more other full-time employees. You will not believe how many times people don't realize this piece of it. There has to be 2 or more full-time employees that supervisor manages. And those employees can't be managed by anyone else. So for example, if you have a supervisor and then you have an assistant supervisor, you can't claim the exemption for the same employees if both the supervisor and the assistant supervisor monitor those individuals. So again, the 2 full-time employees need to be supervised by that individual in order to fall under the executive exemption. Another piece, what you also have to have as an executive in order to qualify for the exemption, is you have to have the ability or the authority to hire or fire employees, or that your recommendations about hiring or firing employees are given a particular weight. All of that needs to be part of the duties, the job duties of the executive. And we could do a whole presentation on the executive and administrative exemption, but I briefly want to touch on and remind everyone what the administrative exemption is. And this is the most abused. The administrative exemption, similar salary basis provision, needs to be paid to salary. But under the administrative exemption, the primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer. This is your typical HR people. Usually, we'll get to the last piece, fall under the administrative exemption. You're not doing the work of the company. You're doing sort of the back office, making the company run. Your finance people who are doing the accounts payable and the accounts receivable, they typically fit into this administrative exemption. But it's not only sort of that non-manual work directly related to the management, but this is often what's the most abused with respect to employers availing themselves of the exemption. It's the employee's primary duty must include the exercise of discretion and independent judgment. So basically, in order to avail yourselves of this exemption, you have to have discretion and independent judgment. An employee needs to be able to make the decisions on their own without having to run it by other people. That piece and that prong of the duties test is often the one that a lot of employers fail on. So again, this is a perfect time, since the law is changing with respect to the salary basis, and Frank is going to get to that, but this is a great time for all employers to really take a look at their exempt classifications. And it's an opportunity now to revisit these classifications, and if there are any issues, if you believe that these classifications, maybe the employee improperly was exempt, this is the time to take a look at it, evaluate it, and consider reclassifying certain individuals, especially since the law is changing rather shortly. And I'm going to turn it over to Frank to talk about the proposed regulations.
Thanks, John. Also, just a quick word about the executive, especially the executive exemption. Those of you who have the matrix structure in your organization where people are reporting to 2 different managers, again, those managers can't claim that exemption, that exemption for that management of that individual exclusively. So if each of them manages that person half of the time, they're only going to get half of the time as a manager. So be careful with that. All right, the current landscape. Well, clearly the Department of Labor's proposal, or the Department of Labor's enforcement, under this administration has become extremely hostile towards employers. They've eliminated early on opinion letters. They've replaced that by the broad administrator interpretations. There have only been a few of those, whereas we were, usually seeing dozen, 2 dozen, 3 dozen opinion letters a year, depending on the activity, the letters that were being sent to the Department of Labor. Now, in 2015, we've seen one administrator's interpretation. This is often very adverse to employers' interests, and it's often we've seen overturning of prior rulings. There have been a number of amicus curiae briefs taking a uniformly pro-worker position, and the Bridge to Justice program brings together workers and attorneys. Okay, so if one of your employees contacts the Federal Department of Labor with a complaint, there will be, my understanding is, 4 different opportunities where the Department of Labor will say, would you like the 800 number to contact a private attorney to take private legal action on this? And that's never been the case before. So it really is somewhat of a hostile environment for employers. The proposed regulations. Well, the salary increase threshold, we're currently under $455 a week, $23,660 annually, is expected to rise somewhere in the neighborhood of $970 per week and $50,440 when the rules finally are issued in 2016. Heading to Washington actually next week, and we'll be meeting with some folks in Congress, as well as I believe I have an appointment or two with the Department of Labor. So I'll be finding out maybe some inside information on when they think they're going to be through all of the comments from the comment period and be able to release those final rules. Right now, I'm hearing that we're expecting somewhere between June and August of 2016. So most likely we'll have a 60-day period to get those changes made. So annual compensation for highly compensated, we're looking at somewhere north of $122,148 annually. That is based on 2013 numbers. So it's probably going to be higher than that by the time they come out with the final rule. Next. The exemption threshold for motion picture production industry for those folks in New York City and other areas where this is important. Presently $695, proposed $1,404 per week for employees compensated on a day rate basis. And the department has also proposed increasing the salary level for exempt employees in American Samoa to $774 per week, or $42.48 annually. So what are some options that employers have? Well, the first option is clearly favored by the Department of Labor and the administration, to increase employees' salary to meet the threshold, so going up to $54.40 annually. Or the employer can divide the employee's current salary by 40, get an hourly wage, pay overtime based on that regular rate, which would also give that employee the opportunity to make more money. Again, makes the administration and the Department of Labor happy. Next, you could divide the employee's current salary by 40 and forbid the employee to work overtime, so they would be making the exact same amount of money. But what most employers that I've talked to are planning on doing is calculating that hourly rate based on the number of regular and overtime hours that the individual normally works, so that it comes out to approximately the same amount right now. Where that creates a problem is when the employee doesn't work those extra hours in a week. So for example, if the employee normally works 50 hours, you're going to have vacation weeks, you're going to have weeks where there's a holiday. The employee could actually wind up making less because they would be working fewer, what would be then called overtime hours. And that would be a real shame for those employees. So there's a lot of kinks to be worked out, but those are the options that most employers are looking at. Okay, next. With that, the Department of Labor clearly acknowledges that about 25% of all employees that are exempt under the current white-collar regs will be non-exempt under the final rules. That's 4.6 million employees who are currently exempt are going to lose their exemption immediately. And they expect anywhere from 500,000 to another 1 million employees to lose exemptions over the next 10 years based on the automatic increases to the salary threshold that we are expecting as part of the final regulations. Now, I know I've had dozens of conversations with employees when we've moved them from exempt to non-exempt for our clients, and it has never, in my experience, been a pleasant conversation. The employees are insulted. They feel like they're being demoted. Get ready, folks, because this is going to be an employee relations nightmare across the board. Next. And again, the DOL also recognizes that employees are likely to reduce work, or employers are likely to reduce working hours for those folks that are currently exempt. So once they're reclassified, there's going to be a reduction in hours, and it could lead to overall a pay decrease for some of those employees, which, again, is going to be an employee relations nightmare and really unfortunate for those employees. Proposed regs were 295 pages long, read every single page, and stayed awake for the whole thing. Again, it was mostly background to kind of support their position. It did not include any percentage of time that exempt employees would be required to perform, or would be allowed to perform non-exempt work, but the DOL is soliciting comments on ways to clarify the exempt status. So for example, whether or not to allow discretionary bonuses to satisfy some portion of the required salary level. They've thrown a bone to us, possibly a 10% level, as long as the bonus is paid within the month, and including appropriate frequency for those bonuses. Next. Whether to modify the current duties test. Now this is where I'm really starting to get nervous. If we, on a federal level, adopt the California rule, this would require exempt employees to spend more than half of their time on exempt tasks. Or they would use some other quantitative limit, but ensuring that the employee is spending a majority of their time or some level of their time on exempt duties and minimizing their non-exempt duties. So this would also require employees who are exempt tracking what they're doing. So can you imagine some of your currently exempt employees having to track whether or not they're making copies or whether they're actually managing someone's time? This could really get very, very ugly. The best way to determine annual updates. They're also looking for comments on how to determine the annual updates to the salary level. So it could be, again, a percentage that they're using now. It could be based on inflation. There are a lot of things that they're taking a look at. Okay, next. Right now, primary duties test, the rule is flexible. In the future, it could be a percentage limitation, 50%, 20%. This is going to have a huge impact on retail and restaurants where assistant managers currently may work more than 40 hours a week. Are you going to make them non-exempt? Are you going to reduce their hours? Could eliminate their positions? So this could get really, really ugly. Next. So as the proposal came out, the increase was from $455 a week to $921 a week. That's $47,882 annually, which is the 40th percentile of all exempt employees in the country. We're also looking, as I said, at 122, 148, the 2013 level for highly compensated employees. We're projected to be with that increase in place already before the final rules are already put out there for us. The increase is expected to be $970 a week, or $50,440 for all exemptions across the board on an annual basis, and the 90th percentile for highly compensated employees, whatever that number comes out to be. And this is an unprecedented way to handle this in the 77-year history of the Fair Labor Standards Act. Never has the Department of Labor set the floor, the very minimum salary amount in this manner. Next. Again, currently non-discretionary bonuses don't count towards the salary level. They're permitting or considering permitting that, but the bonus must be paid monthly. Next. And they're looking at establishing a mechanism for automatic annual increases. Again, the 40th percentile of all salaried workers, as they've used to set the numbers that we're looking at now, and the 90th percentile for highly compensated exemptions. Next. So what do John and I suggest you do, or suggest your organizations do? Well, regularly review your classifications. Start now. If there are people who clearly do not meet the rules right now, meet the requirements for exemptions right now, then they're certainly not going to meet them after the new rules come out. So make any adjustments that you possibly can now to minimize the number of adjustments you're going to have to make in the future. Ensure your job descriptions support your classification. Having job descriptions that don't support the classification because they're old or they're poorly written, or maybe the employee doesn't do what that job description really explains that they're supposed to do because of whatever reason, it's important to get those updated. Ensure all of your supporting paperwork validates the classification, and be especially mindful, careful of the low-paid white-collar exempt employees. One of the favorite examples that they like to use at the Department of Labor is a Dollar General manager who makes $455, $460 a week, and is 5 or 10% of their duties are actually exempt. Those are the types of things that they're bringing to everybody's attention to kind of bolster their position and eliminate those positions from being exempt. Next. Avoid the traps. Make sure your inside salespeople are meeting the requirements of the 7I exemption. Your low-level IT positions are not considered exempt, at least not under the computer exemption. They may meet some other exemptions, possibly. And if 90% of your organization is classified as exempt, 90% or more is classified as exempt, you likely have some misclassified folks. To limit your liability, if you have misclassifications, then you should change those classifications as quickly as possible, and then it'll minimize the effect going forward with the new regulations.
And I just want to jump in terms of sort of practical advice. If you are going to reclassify someone, it's a very delicate process, right? So when you're looking at the new regulations or looking at somebody's exempt status, it's something that needs to be thought out well in advance, because if you bring this to the employee's attention and you change their classification, the question is, well, obviously, what was wrong with this all throughout the years, and there's a 6-year statute of limitations in New York. So we have to be careful when we're going to misclassify somebody, when we're going to reclassify somebody maybe as non-exempt. So the process should be really well thought out, and I think what Frank alluded to earlier is when these new regulations come out and they're effective, that can start a good dialogue with misclassified employees, basically saying the law has changed. Although we believe you likely were considered exempt, with the new regulations, we're taking a conservative approach and we're reclassifying your job, we're reclassifying your job as a non-exempt. So I think it's important that we sort of strategize if we do decide that somebody is improperly classified. I think we also have to look at the risk of when you're telling them that the individual that they are being reclassified, that we sort of have a good discussion with them so as to avoid claims. The one other thing that employers can do, I know we talked about legislative action in New York, and a lot of it was very employee-friendly, but New York, jury waivers and class action waivers are permissible in New York. So jury waivers and class action waivers, basically a class action waiver is an employee agrees as a condition of continued employment that they are not going to proceed in a class action against you. So if you have a lot of misclassified employees, this is something to think about because, again, it will avoid those class actions that everyone's scared of. Everyone can still bring an individual claim. They just cannot bring it in a class forum. Additionally, a jury waiver. I'm a huge fan of jury waivers. Jury waivers, no employer likes to be put in front of a jury, right? Why do we not like juries? Because they always typically tend to side with the employee. So again, you could also implement, and there's all different strategies for doing so, a jury waiver in which an employee waives their right to a jury if they're going to bring claims against you. And that could apply for, not just wage hour claims, but any types of discrimination claims or any claims related to their employment. So those are just some things to think about in terms of if you're taking a look at your staff and you're taking a look at classifications. Those are just some tools that you could have in your arsenal on dealing with what to do next.
I know we've gone over a couple of minutes. We had a few questions. We've answered a few questions online while we were talking. if you still have a question that's there that we haven't gotten to, we will respond to you. Promise that. And on the next slide, there is our contact information. So please feel free to reach out to John or myself or both of us if you have additional questions or need any guidance on how to handle those meetings that will be coming up very soon for you with misclassified employees. I'll be happy to share whatever information I can. And I just want to thank you all for your time and attention today.
Yes, thank you all. I appreciate it. And just to give everyone a heads up, the next one we'll be doing another webinar, probably sometime in December. I'll send out on the same way that we sent it out here. We're going to be doing medical marijuana is coming to New York. Is your workplace ready? There's going to be changes in the medical marijuana law coming into effect in January, so we are going to do a quick webinar just advising everyone of that new law. Thank you all so much.
Thanks, John.
Thanks.